Good afternoon, everybody, and welcome to today's webinar, which is our Eleanor Roosevelt series, Learning from Data Breaches. Can I just check that everybody can hear me okay? If you can just use the chat box to type yes, that would be fantastic.
And me as well, just to make sure. There's two of us today.
Yes, you get the Kelly and Regina double act today. And we are recording the webinar, but all that's being recorded is the screen, not the chat box. So please do feel free to ask questions as we go along. So let's kick off. And I do apologise if you hear any background noise. There's quite a lot going on in my neighbourhood today in terms of development, so you may hear the occasional drill. So my name is Kelly Peters. I'm one of the co-founders of Databasix. I'm incredibly passionate about data protection, as is Regina, and I've got experience in the public, private and third sector. So introduce yourself, Regina.
Yep, I'm Regina Lally, the other co-founder of Databasix, and very similar experience, obviously, with Kelly. You know, we worked together for, I don't know what now, 16 years.
16 years.
So, yes. We've just had this interest in data and data protection and love to share that with you. And so one of the things we've always stated is that if you can try and learn from the mistakes of others, then it's better than learning from your own mistakes. Obviously, you should do that too. And that's the theme of these Eleanor Roosevelt series, to try and help bring to light some insight into the recent high profile or interesting breaches that the ICO or other European regulators have commented on, so that we can bring learning lessons to you. So hopefully you can avoid making similar mistakes, or you can review what your practices are and make sure that you can make changes to secure your own data and hopefully remain in line with data protection regulations. So sorry, carry on, Kelly.
Oh, no. I was going to say what we've got today is two breaches. We're going to talk about the Ticketmaster breach, which Regina's going to talk about, and then we've got a breach that happened in Germany with a laptop retailer, MBB, which I'll talk about. For each incident, we'll talk to you about the breach, and then we'll take 3 lessons. There are more than 3, but we wanted to focus on key 3 lessons from that. And then there'll be an opportunity then for you to ask us any questions that you may have. So let's kick off, and I hope you find it super useful. So Regina is going to kick off talking about Ticketmaster.
So this happened back in 2018, and it was kind of over the period of GDPR being introduced. And I think really it's probably one of the first big ones that was in the news as GDPR was coming in. And obviously we had then the BA and Marriott breaches, which we spoke about last time, but they've been investigated and decided upon prior and before this one. So whilst this was the first, it's probably the third really significant one to come through. So you can see it spans the period, so 10th of February 2018 pre-GDPR, and then across right through to the 23rd of June 2018. So that's a long time that the breach was ongoing. It happened on the Ticketmaster UK website, and essentially the issue was with a chatbot that was used across the whole website, including the payment and checkout pages of the website. So that's a key factor to note. It was a third-party chatbot. It wasn't something that Ticketmaster themselves had produced. And the information, the personal data that was affected was significant. It was financial information, it was full information, so it was name and address, so you can identify an individual, their email address, their entire credit card number, and the CVV number, so that's either the 3 digits on the back or American Express 4 on the front, and in addition then their Ticketmaster username and password. So there's a significant amount of personal data that has been breached. There's financial information that allows hacker to put the individual at risk of financial fraud, and that's exactly what happened. And the reason that it was over such a long period was that the very first identification of a fraudulent activity was back in the beginning of February, and it took till the 23rd of June for Ticketmaster to actually acknowledge that it was their website and people purchasing through their website that was causing the issue. So I think between April and June 2018, various different banks and payment card providers were providing information back to Ticketmaster in different parts of the world that there was a potential issue with their payment process, because the common factor when the banks were looking into significant numbers of cases of fraud was that Ticketmaster seemed to be the common denominator. And yet every time that this was raised with Ticketmaster, they denied that it had anything to do with them. They weren't aware of any issues with their payment process. They didn't see how it could be them. And this was sort of repeated in the report that the ICO put together, that there didn't seem to be an engagement in terms of the facts of the case with Ticketmaster to actually investigate this thoroughly. It was, we're not aware of anything, we don't believe it's us. So the next fact that really the ICO flagged as being an issue was that there was social media feedback to Ticketmaster about their chatbots and potential issue there. One user had identified that there was 2 instances of the code, and in one it had an additional line, and again the Ticketmaster security team didn't take that seriously. They didn't look at or investigate why there was a different code. They brushed it off and they didn't investigate it further. Also, there was a lot of significant antivirus messages coming up about the Ticketmaster website because of this code in the chat bot. And again, it wasn't investigated, and they relied heavily on the third party, which is Inventor, who produced the chatbot, who said no, there was no problem with it. They weren't aware of any issues, and Ticketmaster relied on that rather than doing their own investigations. It was only on the 22nd of June that Barclaycard reporting through a potential sort of 37,000 fraudulent transactions that Ticketmaster acknowledged that there was a personal data breach and that they therefore needed to investigate it and reported that through to the ICO. So the ICO have looked at that period between May and June, so that they're looking at it under GDPR rather than across two different sets of legislation.
And I think it's fair to say that the ICO was quite critical of the fact that Ticketmaster seemed to routinely ignore the messaging that was coming through from the banks. And it was a consistent messaging. I mean, we've just grouped these, but it's literally weekly. They were getting some kind of notification that there were breaches that were occurring. And then they seemed to continue to ignore the Twitter messages that were coming through from users to say, I'm getting antivirus messages, your website is not secure. And in the report that's on the ICO website, they were very critical of the fact that it shouldn't have taken until the 22nd of June to realise that you had a real problem with your website.
Yeah, and it was interesting because I think for me, the one of the scenarios makes it particularly would have given them really strong evidence right from the start. And one of the banks identified, I think it was Monzo, identified that the individual, when they'd been purchasing their tickets for whatever event they were going to, had accidentally put in the wrong expiry date.
Yeah.
Which meant the transaction was declined. And then within a few days, that information with the wrong expiry date was tried for fraud elsewhere.
Yeah.
And I think that's what, I mean, they refer to it as a smoking gun. Really, that should have rung huge alarm bells for Ticketmaster, because that, for me, would be enough to say, well, clearly it's come from that erroneous input if the customers indicated that's what happened.
Absolutely.
So I think just as well in terms of numbers, they looked at originally, it was potentially 9.4 million European Economic Area citizens who were affected, and 1.5 million of those were in the UK. Ticketmaster received about just under 1,000 complaints from individuals with in relation to financial and emotional distress. Some of the banks automatically replaced cards that they knew had transacted with Ticketmaster. And I think Barclays, in the end, it was initially 37,000, but reported through around 60,000 fraudulent financial transactions. So the numbers are not insignificant of individuals who were affected. So in terms of the lessons that we can learn from this, I think, Ticketmaster are a huge company. They have processes in place. I think, the next couple of learnings will evidence that they may not necessarily have followed them all. However, hackers, will look for where they can get maximum gain and for weak links in the chain. And so if you are looking at using third-party suppliers for any elements of your business, you need to be aware of the potential risk that they're putting you at. So in this case, it was a chatbot that was provided by a third party to Ticketmaster. They very much, throughout their entire defense, tried to indicate that it was Inventor's responsibility to ensure that the security was appropriate, and almost tried to alleviate themselves of any kind of blame. That didn't wash with the ICO, and I think Ticketmaster couldn't demonstrate that they'd taken the appropriate steps as a data controller to establish the mechanisms and security protocols that were in place on their data processes, which is what Inventor was. So there was no independent verification of the assurances Inventor gave them around their security. They did no checks on the code. And I think the fact that there were Twitter users out there saying, I've identified that there's a difference in these two codes for the same thing, and the third, there's an additional line. Why was that not a huge, massive red flag to say we need to do some verification? We need to actually check what's going on here. So I think really the lesson here is to not necessarily fully accept the easy assurances that might come from third-party processors. Think about what you can do to check yourself, or to get a third party with the expertise to check, and make sure that you've got processes in place and that you document those checks that you've run through.
And I think the interesting thing about this was that if you think about it, we all have websites. We will all find new interesting plugins that we think are going to benefit a visitor or a user of our website. But just because it looks new, it looks funky, and it could really help us, don't forget your responsibilities as the owner of that site, that you need to do all the due diligence, because it just shows how easy it is for a small little piece of code that then ends up causing significant amount of damage, both reputationally and financially.
And I think as well, just thinking about where you apply some of those technologies. So for example, the code wasn't, the chat box didn't necessarily need to be on the payment page. And if it hadn't been on the payment page or the checkout page, then the information wouldn't have been scraped. It would have potentially been less of an impact on individuals. So, the implication we'll come on to next, we'll pick up on that as well. But I think don't just blanket apply something, really think about the risk of the data you're collecting at each stage of the process, and determine whether or not it's necessary to have a plugin or third party that might open you up to more risk at that point.
Nice.
So I think there's, again, the second lesson that we're looking at here, and we've alluded to it, is really trying to understand where you can pick up intelligence and understanding and early kind of warning for any issues that might be putting you at risk. So the reputational risk here, obviously, on Twitter, if you've got people indicating that they think that there's an issue with your website, that there's potential malware in your website, and are very clearly actually giving you the evidence of that, it's really important that your social media team or people who are responsible for security have visibility of the kind of information that can be picked up on social media about your organization, and that there's a process then to raise and escalate that. So don't just ignore it, and don't just try and sweep it off as somebody doesn't know what they're talking about. If there's a few of these coming through, or it should be taken seriously and assessed, and then fed back if it is erroneous, or actually acted upon if it's not, as in this case. They had, so it was in May, so that would have given them an additional month's worth of time of responding, and fewer people being affected if they'd have responded in the first instance, rather than the sort of Twitter staff saying, no, it's not a virus, it's to help with our, I think it was very dismissive, it's to help with our customer service plugin, it's nothing, there's no virus in it. So there's a real issue there around staff training for the social media staff who may not have the security knowledge or the in-depth knowledge, but it's about what's the process for them to raise it with people who do know, and then how can you monitor what's being said about your organization on social media. So you can follow hashtags, you can do searches every now and then. There's tools that may help you do that. So looking at all across, there might be other areas that would support you in as well, in terms of the brand risk or reputational risk if people are giving feedback. However, in terms of that security risk, it could be a really early warning, because you've got people out there who are experts who flag these things, and then they share it on social media to warn other people or to try and raise it with you. And if they're directly messaging you and it's in the public domain, you really need to think about a process for responding to that. So rather than just ignoring them and trying to sort of go, oh, no, it's all fine, don't worry about it.
Yeah, and I think there's the added of, if your social media team, and your social media team sounds grand because we're talking about Ticketmaster, but if you are the social media team, the temptation is always to respond immediately. But I think for me, is that you need to really take a moment to be like, what exactly are they telling me? What do I need to look at and investigate before I respond? Because clearly these responses were part of the investigation, and the quick response of, oh, don't worry, it's not us, we're not the problem, did actually look poorly on Ticketmaster.
Absolutely. And it was taken, as you say, the ICO took that into account and saw it as an opportunity that they'd missed to act. And again, the ICO, they try not to act with the 2020 vision of hindsight, which again, Ticketmaster were trying to argue that they were doing with the fine. But I think all of us would accept that that's a reasonable flag, the beginning of May, for a user to say, there's a potential issue, here's the code that I've spotted that's a problem, and that nobody's picked that up, that that's not the benefit of hindsight, that is actually clear evidence at that point that should have been investigated further.
Yeah, what I found really interesting was the fact that Ticketmaster said that they only became aware of the breach on the 22nd of June, and it's when you as a company become aware of the breach that you then need to take action in terms of notifying the Information Commissioner. And I think what I found really hard is all of these steps beforehand, where you say, well, you've had users tell you, you've had banks tell you. How can you really, hand on your heart, argue that you only knew on the 22nd that this was a breach?
I think they went down of confirmation, but actually, if you look at the legislation, it talks about potential breach.
Yeah.
So even if you're not sure whether there's been actual access to user data, if you suspect there's been a breach, you have to assess what it could be and then investigate further. And I don't think the ICO agreed that they couldn't, hand on heart, say that was the case. And then moving on to the third lesson, it's really looking at how you're applying and implementing changes. And I think, in the current environment we're working in, it's something we've referred to in other webinars. At the moment, with the fact we've had to switch to working from home, there's new technology, new things coming on all the time that can help us as businesses operate. It can help your customers have a better user journey. And the temptation is to implement as quickly as possible, so you start feeling the benefits as quickly as possible. And I think what we'd always urge the caution is to take it step by step. Think about how you're implementing those changes. For this, they were, looking at implementing a chatbot. There's evidence out there that indicates that users are keen on chatbots. It means they don't have to pick up the phone and hang on the line. They can get some initial information that they need, and normally they're very helpful. However, is it necessary? Is it appropriate to have a third-party plugin, chatbot, on a payment page? What's the additional risks and things you need to be aware of? And this was something they didn't Ticketmaster didn't look at. They didn't believe that the chatbot would be processing the payment data, and therefore didn't check on the PCI DSS status of the organization. However, because that chatbot sat on that page, it needed to comply in the same way as Ticketmaster. And whilst they didn't store any of the information that was collected on that page, their plugin opened it up and opened up that page and the information being collected on that page to the virus and to the information being sent off to the third party, enabling them to then use the data elsewhere for fraudulent transactions. So again, Ticketmaster argued that it didn't believe that they were storing the data, therefore they didn't need to be PCI compliant, but simply for the fact it was on this page, they should have been, as should the hosting provider, and they weren't. And the other point that the ICO made at this point was that there was no evidence of any kind of process of review of their service providers. Ticketmaster didn't have a regular or routine program of review of compliance for the PCI DSS compliance, and that's something that law requires, as well as obviously the accountability part under GDPR. And so opportunities that they could have had to identify again that there was issues, or that the provider didn't have the required compliance levels given the page that it was available on, it was something again that the ICO flagged. And I think that was as a mini fourth bonus learning lesson.
Nice.
The ICO flagged, and I think that there was a number of occasions that they stated Ticketmaster were unable to provide them evidence of processes that should have taken place, and that I think that's had an impact on the level of fine, because they haven't been able to demonstrate their accountability as a big organisation for processes around risk assessment, compliance, and review processes. And that's something that we always try and encourage organisations to have, is that documented process. It can feel like a pain, but if you keep things and document your thinking and your reasoning and your processes and your reviews, you will be in a much better position when it comes to investigating any kind of issues that arise, and being able to demonstrate how you've tried to comply and tried to protect the data. And I think that was part of a much bigger issue here, is that Ticketmaster, whilst they had documented processes in place, hadn't followed those processes and hadn't been able to evidence that they'd followed those processes internally or with their third-party provider in this instance.
Awesome. So that was a really good synopsis of Ticketmaster. I'm going to talk you through a different breach in a different country. And yes, we're no longer part of Europe. However, they have applied the GDPR to this, and there has been a lot of increased employee surveillance that's gone on in the last 12 months. So I thought it'd be quite important just to raise this particular story here, just in case any of you are thinking about employee surveillance or customer surveillance for that matter. So MBB, notebook.
Bildungsbilliger DE.
Thank you.
As the German
the German speaker of the two of us can confirm the name. They were fined by the German regulator 10.4 million euros because they were illegally having surveillance in place of its employees. It also picked up customers, but the main focus was really on the employees. And when the German regulator contacted the company to say, why are you doing this? What is the purpose of your surveillance? They claimed it was simply to prevent and investigate criminal offences. However, what the German regulator said was, you're collecting data for far too long. You don't seem to have really considered the impact on the privacy of your staff. So they fined them the significant money. And this comes after the German regulator fined H&M 34 million euros a few months before, again for employee surveillance. So I'm going to take this story and then I'm going to use some of the additional UK regulation for you to consider if you are deploying any type of surveillance in your organisation. So what happened was that between 2018 and 2020, as far as the German regulator can identify, they think it might have gone on for longer, but they are confident that between 2018 and 2020, MBB had been video monitoring its employees without any basis. So if you were going to be relying on something, it'd be potentially along the legitimate interest, but they hadn't defined the lawful justification for processing this type of surveillance. The cameras were in multiple locations, in workplaces, in sales rooms, in warehouses and in common areas. And again, collecting a significant amount of continuous video recording 24/7. And the other kind of thing that they really brought to home was that they were keeping it for 60 days, which the German regulator was very clear was significantly longer than would ever be reasonable to be necessary. And looking at the ICO code of practice for CCTV, they would also agree with that, because it's so intrusive. And you had a very specific purpose about security, the retention period that was used was felt to be far too long. So they were inappropriately recording staff and they were keeping that video footage for far too long. So what was quite interesting was when I was looking at this was when the German regulator investigated the organisation, they said that at no point in time had there been any kind of privacy impact assessment conducted on this surveillance activity. And what the ICO says, so if this was an incident that was to happen in the UK, what the ICO state in their guidance, and they do have a very specific code of practice for the use of CCTV or body cams or however you're recording and surveying your staff or your customers, the code of practice sets down a standard that you must adhere to. And it says you really must understand what is the problem that you are trying to address. So understand that first. Is surveillance the best way of doing that, of resolving that problem? So an example that they give is that if you know that cars are routinely being damaged in a car park, could additional lighting in the car park be a better preventative measure than simply putting up CCTV? Mm-hmm. So what they always, and this is the same for the German regulator asked, could there have been something else you done or do before you decided that video surveillance was your option? So it's almost as you should be thinking video surveillance last, as an absolute last option. Have you considered everything else? And a data protection impact assessment would actually allow you to consider all the different risks and all the different countermeasures that you could put in place, and whether or not you'd have to write off one to say, actually, it's too risky, we simply can't go ahead with this. And what's the impact on the individuals? You know, will they think that it's fair for you to be constantly streaming imagery of them? So I would say to anybody on this webinar, or anyone's listening to this webinar, that whilst people think that CCTV is a good way of being able to support an investigation into a claim of negligence or theft, always think about the impact on the individual and whether or not there is an alternative means to be able to resolve the problem before you go down the video surveillance route. And the German regulator has been incredibly critical about this, because, like I said, this is the second fine that they have issued. And from a UK perspective, an automatic registration with the data protection fee is CCTV. So the first question they ask you is, do you use CCTV? And if your answer is yes, you have to pay a data protection fee. So that should give you an indication of just how serious the ICO take video surveillance. Now, the other point that the German regulator said was that you have to have a reasonable retention period. 60 days was felt to be absolutely unnecessary. So you need to be thinking about what is the shortest amount of time that you need to hold this file for that's going to support the purpose for what you're processing that data for. It shouldn't be as long as you feel it's necessary. It's what is the quickest amount of time that you can hold this data on to resolve the problem. And that should be your retention period. And then you must have a very clear process of deleting and destroying that record. So whilst the Data Protection Act in the UK and certainly the GDPR doesn't prescribe retention periods, what it does say is your responsibility as a data controller to understand minimum and maximum retention periods and then justify the reasonableness of that retention period. And it has to reflect that purpose. So whenever Regina and I have talked about retention schedules, a lot of people just say to us, oh, it's 6 years. And I'm like, well, no, your organization may have 100 different purposes of processing data. Therefore, you may have 100 different retention periods that you need to follow. So what's the purpose? What was the retention period? And is it reasonable? And if you've done the data protection impact assessment, you should have been considering retention periods at that point. And if you'd gone out to consultation, the outcome might have been 60 days is just too long. So the German regulator was very critical about the fact that it was too long. And if you read the ICO code, they typically suggest 30 days for a lot of the CCTV. When they're giving their examples, it is a very short amount of time.
And I suppose factors that organisations should be considering there in terms of purposes is then thinking, in what period, if CCTV largely will be for security purposes and that type of thing. So it's then thinking realistically, what are the incidents you're trying to prevent?
Yes.
And how long after those incidents happen is it likely they're going to be reported? So, one of the things that we'll typically see will be that there'll be a standard retention period for the recordings, and that they will be generally, for the most part, somewhere between 14 and 30 days, and they'll typically overwrite so that it's just, that's what's available. Obviously, then, if there's a need to go back and look at the footage because a complaint's received, or there's a suspicion of some kind of illegal activity that's then being investigated, you can then, once you've looked at it, you can take those images and the recordings and obviously separate them out, and then they should also have the consideration of how long they're needed for in terms of the support of the case and any ongoing investigation, and what happens if it's deemed that there's nothing wrong with that particular complaint, and what happens then. So think about just wider than the recording itself. It's what happens with when they're used and the purposes associated with them, and make sure you've got a process for securing those in how they're accessed.
Yeah, absolutely. And they were the ICO guidance, as well as the German regulator, was clear that you also need to be thinking about the placement of these cameras. Yes, you've got multiple areas, but along with the purpose, that should support the placement of where these cameras are, along with the notices, so people are aware that there are cameras in place. Now, the point that they were most critical about was the fact that they couldn't justify a lawful basis for processing this. So though they said it was for security purposes, the German regulator said, well, you can't demonstrate that to us. There's no rationale, there's no thinking, there's no evidence of the decision making around your lawful basis. Now, typically, the basis that people rely on when they're capturing CCTV is legitimate interest, because clearly it can't be consent. You're unlikely to be covering it as part of a contractual requirement, and there isn't, as far as I know, any law supports the kind of this type of collection. So it has to be legitimate interest. Therefore, it's your responsibility as an organization to have done the legitimate interest assessment, and that 3-part state of what's the purpose. Is it absolutely necessary? And that's a key one, followed by the what's the balance between what you want as an organization and the impact it has on the individual, and that will support your decision as to whether or not you have a legitimate interest for using CCTV for monitoring your staff. And if you don't, then you simply shouldn't go ahead. And that is what a regulator would want to see. They'd want to see that assessment so they can understand your rationale for this type of reliance on legitimate interest. And some of the questions that they said that you should have been thinking about, or the organization, and what you can take away from today, the listeners, is why do you want to install CCTV? Or, or phone recordings for that matter, or if you wanted to have employee monitoring through webcams, for example. So why? What are you absolutely looking to achieve through this operation? Who has access to it? Because today we can access video, the live stream via your phone. Is that appropriate? Have you limited who has access to it? Can they take copies of that off of their phone, for example? How are you going to provide? And this is quite an important one. If an individual asks you for a copy of their data, how are you going to support that? As part of a subject access request, and what are the risks to the data subjects in terms of that monitoring and stuff. So that should all be some of the things you should be considering when working out that if you have a legitimate interest. And the answer is, if you come back with a lot of no's, then you will not be able to justify your processing of that monitoring. So it's not to say you can't. All that this particular example really puts the onus on you to make sure that you have considered the impact on the individuals, that you can justify the processing of it, and that you have, as Regina said in the previous example, from an accountability perspective, you have that evidence, so that if someone says to you they think you've breached, you've got a better chance of having a discussion with the regulator rather than it being a flat, no, you've broken the law. So it was an interesting one, and it'll be interesting to see if the UK follows. They have fined companies for inappropriate use of CCTV. There have been companies that have been fined for this, so it's not just the German regulator, but it was a good example to use. So we've got some time for some questions. So do anyone on today's webinar, do you have any particular questions, or are there any points that you want to share with us, or was there anything that we said that particularly resonates with you? Feel free to use the chat box.
I think the on that last slide there, it was quite interesting, the sort of subject access request, and I imagine that people wouldn't always consider that somebody's image may well be requested or required, and I can only imagine the horror at the point at which that they would realise that they needed to include that, and how they can find that out. And again, it's similar with call recording, because your voice is also personal data, and there might be information captured on that recording. So I think with any of that kind of new data capture, thinking about how you can make and give subjects access to it if they request, or how you respond to it or get support in responding to it, is key, because there may be ways that you can help yourself in the way it's stored, but also then that may also affect how long you hold on to it in your retention period decisions, because obviously if you've overwritten it and you don't hold it anymore, then
and then it's the redacting of other people in that video recording as part of that, providing that video footage back. It's a really good point. So feel free to type any questions for us. We're more than happy to answer. Hopefully it was a useful webinar for you to have. What I would say is, whilst I can see there have been someone trying to type a message, just to kind of say, if you wanted to, maybe you didn't feel comfortable asking something in the chat box, you can obviously talk to us directly. We can help you. We can help organizations if they need a rapid response to a data breach. If you're in a panic of, oh my God, what do I do? If you need review of your data protection policies, because listening to us today, you might think we don't have a data protection impact assessment process, or we don't routinely review our legitimate interests, or we haven't looked at our supply chain, for example. I would hope that you feel that you could call upon us if you needed. And, we do a lot of staff training. There are plenty of free resources that we have available to you. We have a podcast. We talked about Clubhouse in our recording of a podcast, which is going to be available next week. So go on to Spotify, Google, and where else are we?
Apple Podcasts and Podbean as well, if you happen to listen to Podbean. So yeah, we're everywhere in the podcast world.
And we've got a lot of free materials in terms of blogs that might be of interest to you. So feel free to check out our website. I'm glad from some of the commentary that you found it's been really interesting. If there are no questions, please do give us any feedback on how you found the session. It always helps us. If there's anything you particularly want to talk about, we're going to be talking about cookies in March. So hopefully that will be of interest to everybody on this webinar and who listens afterwards. But if there are no questions, thank you very much for taking the time to listen to me and Regina. I hope you all have a fantastic rest of today. And I hope you can join us again at a future webinar. So thank you all very much for your attention.